So I recently saw a post on Facebook in a real estate group that I'm in, and the agent was talking about a deal of hers that had blown up because of the mistake of a divorce attorney. And as someone who is not only a realtor, but an attorney who practices real estate law and in another lifetime practiced divorce law, I kind of see it from all angles. And so I want to talk to you about a common mistake that divorce attorneys make that could potentially derail a home sale. My name is Sharon Smoot. As I said, I'm a realtor and a residential real estate closing attorney in the metro Atlanta area. So let's get right into it. I am going to include a screenshot of the Facebook post somewhere in this area so you can check it out. I'm not going to read it to you. You can read it yourself. But essentially, this agent is sharing that one of her deals is falling apart because the couple is divorced. The wife was awarded the property in the divorce, and the husband's name was never removed from title, and he is now refusing to sign the necessary quitclaim deed to get his name off. So you'd be surprised that even the most experienced divorce attorneys make this mistake. I have seen it time and time and time again over the years. And I don't know why they skip that last little step when their client is awarded a piece of real estate in a divorce. So here's what happens. The couple goes through the divorce proceeding, and as a part of the final judgment and decree, sometimes there's a jury trial, sometimes there is a settlement between the parties, and the settlement agreement is incorporated into the final judgment and decree. If it's a jury trial, whatever the jury decides is written up and made a part of the final judgment and decree. That order says that this spouse is awarded a particular piece of property. That is not the end of it, at least not in Georgia. Maybe in other jurisdictions, the settlement agreement or the final judgment and decree acts as a conveyance, but in Georgia, it does not. So once that order is entered, the final step is to have the party whose name is coming off of title to sign a quitclaim deed. If that doesn't happen, and at some point in the future, whether it's 6 months, a year, 5 years, 10 years, the spouse who was awarded the property goes to sell it, and that other spouse is uncooperative or dead, there could be a problem. So it is essential that when you are going through a divorce and you are awarded a piece of property, that you make sure that that last step is taken care of. Now, there may be circumstances that dictate that that deed cannot be recorded immediately. For instance, if, let's just say that Jane is awarded the property, but both Joe and Jane's name are on the mortgage, and that final judgment and decree says that Jane has to refinance the mortgage in order to get Joe's name off of title. It would make sense that Joe would be a little bit hesitant, like said, no, I'm not, as long as I'm still financially responsible, I'm not taking my name off title. What should be done is that that quitclaim deed be executed and held in escrow. In this case, I would say by Joe's attorney until the refinance transaction is closing, at which point Joe's divorce attorney would forward that original document to the closing attorney to have it recorded at the time that the new security deed from the wife to her lender is being recorded. Maybe there's a situation where Jane has to pay Joe a certain amount of money. Maybe her name is on the mortgage, both names are on title, and she has to buy out his equity. And so rather than refinancing, maybe during COVID, she got one of those 2% interest rates and she doesn't want to lose that. So she's just going to liquidate some other assets, maybe get some money out of her 401k to pay Joe his equity. And until that is done, that deed would be held in escrow by one of the divorce attorneys. But my point is that when someone is awarded property, that quitclaim deed should be executed immediately. If it's not going to be recorded immediately, one of the attorneys holds it. Once it's time for it to be recorded, whatever that date specific is, that triggers the right of the person who was awarded the property to have that deed recorded, the attorney holding the deed gives it to the closing attorney and it gets recorded. Simple as that. So if you are a seller in a situation like this, make sure that your attorney takes that last step to secure that deed because you don't want to be caught out at some point in the future unable to refinance or unable to sell the property because your ex is being uncooperative or is dead. And if your ex is uncooperative, that means that you may have to go into court, file a motion for contempt. That's more money for attorneys. That's more time. It prolongs your ability to sell or refinance. If you are a divorce attorney, you need to be making sure to take this last step because you don't want to be facing a malpractice claim because you didn't. And for as long as I've been practicing law, about 33 years, I have always said every divorce attorney needs to have a relationship with a good real estate agent to refer clients to when they need to sell properties pursuant to a divorce. And they need to have a good real estate attorney on tap as well, so that if they're uncomfortable drafting a quitclaim deed, they can have their real estate attorney colleague draft it for them. That's what we're here for. But my point is that nobody, whether you're the seller who's been divorced and awarded property and you're trying to refinance or sell, or you're the divorce attorney who represented the client who was awarded the property and they're now trying to refinance or sell, and there's a hiccup because you didn't complete that last step, or there's a hiccup because your attorney didn't complete that last step, you don't want to find yourself in that situation. So make sure that that last step is taken when a client is awarded a property or when you, as a part of your divorce, are awarded a property. Secure the deed, secure the quitclaim deed.